Good morning. This is Rich Sierra, president of the Florida Small Business Legal Center here in Boca Raton, Florida. I'm an attorney, been practicing business law for the last 18 years. This is episode number 2 of Business SOS podcast. What I'm going to talk about today is mistake number 8, initiating or staying in a business lawsuit on the basis of principle. Before I go into that, one of the analogies that I can give you in terms of what a lawsuit is for, and if you've been involved in a lawsuit, whether you have sued someone or you have perhaps been the recipient of one, neither of them are pleasant. What I tell my clients is that a business lawsuit is like being in a bar fight, or any type of lawsuit for that matter, is that there's going to be a battle between you and your opponent. In this particular case, is through paper, but nobody's going to come out unscathed. There's going to be times that, in some cases, you might be the recipient of a bad motion or a bad order, and vice versa. A little bit about my background. I'm a martial artist. Been practicing martial arts since I'm 9 years old. Now I'm 58. And on and off. And for the last 20 years, I've been more active in the martial arts. I hold black belts in Taekwondo and Judo. And I have also a purple belt in Brazilian Jiu-Jitsu. I've been practicing that for the last 6-7 years. I've competed in national, international competitions in Judo and Jiu-Jitsu. It is a very unnerving process. Your adrenaline rush is very intense. And then when you face an opponent that his whole mission is to either choke you, immobilize you, throw you, or to put you in some type of submission like an arm bar or a knee bar, it really raises all your senses and your focus in trying to protect yourself and hopefully beat your opponent. It is a competition, so obviously there are rules, and there are rules of engagement of what you can and cannot do, but injuries can happen. Fortunately, it is time-based, and there are rules that protect you with the referee, and then you basically have that experience and move on. So I do bring a lot of principles of the martial arts into my practice, into my life. It's a big part of my life, and I truly enjoy it. So certainly looking forward to go back in the mat very soon. I stopped when I got a hip replacement 2 years ago. But I certainly want to go back in some fashion. And right now, the way I'm contributing, I'm a proud sponsor of the national team of Key to Sight National Training Center here in Coconut Creek, Florida, that they send this future Olympians to national and international competitions. It's truly one of the best training centers in the entire country, and people travel all over the world to train here. We actually have a number of Olympians from the club, including Angelica Delgado, who has been now to 2 Olympics. So I'm very, very excited to support that team. But let's go back to Business SOS. This is a book that I wrote, been writing for the last 10 years, and finally got released in January of this year, 2023, has been very well received. And book title is Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. And just to give you a little bit of insight on the book, it's basically a conversation. It is not a treatise on cases or how-to manual and forms. It's really my experience with business owners when I found out that the reason that many of them came to my office, they came for the same problems, whether it was a contract issue, whether it was a litigation issue, whether a partnership issue that a partnership did not go well, whether it was a time that one of the vendors sued them or they sued a vendor. And I realized that many of these problems could have been avoided with some prevention or some advice in the first place. So that's why I wrote the book. And some of my clients call it as a reference manual. And I think it might be, because every chapter is independent. Every chapter has something to offer. And the reason for my podcast is that I want to give you, as you're giving me your time, and I do appreciate the privilege of your time, is to, when you finish listening to me, you perhaps get an idea, a nugget, get something, and say, you know what, I never thought about that. I'm going to look into this, into my business. And that is the purpose of it. And also want to perhaps invite you to be part of the show. So what I'm going to like to do is basically, if you have a legal issue that you want me to discuss, and I will not mention your name, mention your situation, I'll basically, if I select your topic, I'll send you an autographed copy of my book. So at the end of the show, I'll basically, the podcast, I'm calling it a show. It's only number 2, so who knows? At the end of the podcast, I'll basically tell you how you can reach me and how you can be part of the podcast as well by participating, sending me your questions or your legal issues. And again, if I select yours, I'll send you an autographed copy of my book. But let's get back into it. Let's get into the topic today. I'm going to talk about mistake number 8, initiating or staying in a business lawsuit on the basis of principle. Business lawsuits, for the most part, are about money. There are some of them that deal with injunctions. They might have to have a court order to stop someone from doing something, whether it's a non-compete, whether it's a contract that they agreed not to solicit employees. So in some cases, there's a reason why you want to have an injunction placed in court to prevent that activity, that action from happening. But for the most part, when you're talking about business litigation or a business lawsuit, it is about money. It's about some money that either is owed or damages that somebody suffered as a result of a breach of a contract. So in my experience, 90+% of these lawsuits involve a breach of contract in some fashion. So what happens if you get sued? Say, a vendor feels that you breached their contract, you did not pay them the way you agreed upon. I'll give you an example. Say in software, there's sometimes softwares that companies develop and they're not happy with the results, so they perhaps perceive that the actual outcome, the actual product was not what the client expected. So the client decides not to pay. So the software company decides to sue, say, listen, I developed this product for you. We're entitled to receive compensation. And that's where the dispute begins. So say you're the recipient of this lawsuit, what do? The first thing is, if you know there's a lawsuit that's going to be sent to you or you're aware of it, do not avoid service. It's not a good idea. Just receive the lawsuit. Just say, you know what? Somebody calls you, and process server, for example, says, we have a lawsuit to serve. Just accept the lawsuit. And number 2, do not panic. You don't have to sign anything. They just hand it to you, and they file something what is called a return of service. And the process server will sign an affidavit basically saying that you were served in this particular date and time. And then you go ahead and and that's all you have to do. There's really no need to avoid service. There's no need to hide. Just accept it. The good news is that in most cases, you have time to respond. So you receive this lawsuit. It's called a summons along with the complaint. And so when you receive it, the first thing you have to do is do not panic. There's no reason to panic, especially in a business litigation context. If you're in business, it's likely that for a long time, it's likely you will have a dispute some way. Sometime along the way in your business career, you will have some type of business dispute. It's going to happen. If it hasn't happened to you, you're very fortunate. Hopefully it will not. But if it happens, it's no big deal. Disagreements happen all the time. So do not panic. You receive it. Obviously, you're going to read the lawsuit, and then you're going to be angry because there's a lot of allegations that are written in this complaint that are not true, that you're going to believe this is just not true. And in some cases, they're inflammatory. So in that case, do not get upset. It is upsetting to receive a lawsuit, but try to take it in stride that it was written by an attorney based on the information that was provided to him or her by the client, which is your opponent, your opposing party. So this is all the information that they have, and they write the lawsuit in such a way. Writing complaints is an art, and there's specific methods, specific ways that we have to write the lawsuit in order to survive what we call a motion to dismiss. So you have to write the minimum allegations that entitles you to relief. So it has to be specific, it has to be clear, and the allegations have to meet with the elements of the cause of action in the case, say, for example, a breach of contract. So you're going to be getting this lawsuit, you're going to be very upset, rightly so. The first thing you got to do is basically retain counsel. If you receive a lawsuit, especially that is, I'm not talking here about small claims. Small claims you can handle yourself for the most part, although it's good to consult with an attorney. But if you receive a lawsuit, anything over, $8,000, which is in Florida, that's above small claims, or if it's drafted and it's actually an attorney is the one filing this lawsuit on behalf of the opposing party, then you have to get an attorney. That's the first thing you have to do. Before you do anything, you have 20 days to respond. And so use the 20 days wisely. Don't sit on it. Don't talk to anybody else other than your spouse about the situation, simply because anybody else you talk to outside of this lawsuit, can be called in as a witness to testify. And those are the questions that we ask to our opposing party in a lawsuit. Is said, have you spoken to anyone other than the attorney or your spouse about this litigation? If the answer is yes, then we have the right to, and the authority, if we want to go ahead and depose the party that you spoke with about this lawsuit. So you receive the lawsuit, you sit on it, unfortunately you probably won't sleep at night, but it happens. But the next thing, you just call an attorney. Make an appointment with an attorney. Go ahead and that understands the type of lawsuit or the situation you're in. In this case, we're talking about business law. So a business litigation attorney will be the most appropriate one to call. And then make an appointment, whether it's a phone, virtual, or in-person consultation, and discuss the lawsuit with that attorney. You talk to more than one attorney, that's fine. Any conversation you have with an attorney about this lawsuit, it is privileged and confidential. It's attorney-client communication, regardless of whether or not you retain this attorney to represent you. But at the very minimum, that conversation is protected and no one can ask that attorney to testify regarding that communication that you spoke with that attorney. So you go ahead and speak with an attorney, and then you find an attorney that you feel comfortable with, that understands your situation, you feel that has the ability to solve whatever legal problem that you're facing with. It's within the budget that you have established or you're able to afford, and then you retain counsel. So you retain the attorney. The attorney, in this case, will file notice of appearance on your behalf, and then begin the process of defending your case. One of the things that to consider and how to handle a lawsuit is basically, say, in a breach of contract claim, say, for example, they're suing you for something like $50,000. So that's not a small number. So one of the things that you have to decide is how much money am I going to spend in defending this lawsuit? And what I tell my clients is this: lawsuits is a battle of resources, especially in the context of business litigation. It is a battle of resources. whoever has the most resources has the greater ability to win that lawsuit. And I'll tell you why. Because lawsuits are expensive. In fact, I could read a little bit excerpt of my book. The Small Business Administration, the SBA, reports that the cost for litigation generally range from $3,000 to $150,000, with approximately one-third of cases costing $10,000. Figures are that are likely even higher now than when initially reported. This was a 2005 report from the SBA. So you're talking, many years later. I will tell you that a breach of contract lawsuit could easily exceed $25,000, $30,000, $40,000. If you have, depending on the number of witnesses that you have, depending the number of documents that you have to go over, a lawsuit can be very expensive. So you have to make that cost-benefit analysis about, if you have to defend it, your objective should be, how can I get out of this as soon as possible? Before I go further, I want to make it very clear that what I'm talking here are concepts, and this may not apply to your particular situation and should not be construed as legal advice. So one of the things that you have to look at is, okay, I'm suing for $50,000. How do I get out of this? So there are a number of options, obviously. One of the things that I try to do in my practice is really triage it and say, first we look at the defenses, look at the facts. A decision on a counterclaim has to be made whether or not you will want to sue the other party in return, because that decision has to be made fairly quickly when you file what is called the answer and affirmative defenses, if it's what is called a compulsory counterclaim. Compulsory means that if it's related to the same matter of your lawsuit, you have to assert that counterclaim, or you have to file the counterclaim when you file the answer. Otherwise, it could be waived. But that's really more the conversation to have within you and your attorney, because if you decide to file that counterclaim, you're basically doubling the lawsuit. Not only you are defending your own lawsuit, but you're also filing a separate lawsuit that they will have to defend as well. So basically, there are two simultaneous lawsuits. And a counterclaim, obviously, it is a defensive strategy because you're basically having them go on the defensive. Your opposing party now has to defend the lawsuit as well, as opposed to being in the offensive. So it is, when applicable and when the time is right, a counterclaim, it is an effective strategy to push back, if you will, your opponent from basically putting you in a defensive position. So offense is better than defense. That's basically my opinion. One of the things that you have to look at is that lawsuits take a long time to decide. And I just did an interview with Logan Crawford, the Emmy Award-winning reporter. And he has a show called Spotlight with Logan Crawford. We spent 30 minutes talking about Business SOS, and we talked a little bit about lawsuits. And in fact, this video is in my YouTube channel. If you go to YouTube and type Florida business lawyer Rich Sierra, you'll see the YouTube channel come up, and the interview is there. But one thing that I told him was that 80% of litigation is about procedure and process. It's not about the facts. So you're talking about a lawsuit that will take approximately, in a good year, in a good day, might be taking 12 months. But a lawsuit can take 18 to 24 months. So you have 80% of the time spent on that initial lawsuit, and that the lawsuit is about procedure. We are doing discovery, we're doing depositions, we're reviewing documents, we're basically filing motions to try to eliminate the lawsuit, which are called motion to dismiss or motion to strike. There are hearings in front of the court. There are orders that are made that every time the judge makes an order with that particular case or your case, then new things have to happen with that case, because there's either you have to amend the pleadings, the complaint, and then you start all over again. So that is basically most of the time is spent in discovery and procedure. And it is a bit frustrating because when a lawsuit is filed against you, you feel helpless, and rightly so. Primarily because you feel that the attorney and the judges have all the control. You have no control. Excuse me a second. So when that happens is because the lawyers are trying to figure out a way to neutralize the case by put it in a place that you're in a better position to go to trial. So 80% of the time during the course of the litigation, we're spending time and resources fighting the other side, or basically being offensive with respect to trying to reduce your risk in the lawsuit, whether it's a claim that was not properly pled, some type of mistake that was made in the lawsuit that we need to remove from the lawsuit. So by the time that the lawsuit goes into trial, the only allegations that are left, the only claims that are left, are the claims that survived all the challenges, judicial challenges that we place. So it is very frustrating for you, the business owner, that this lawsuit is going around and is basically clouding your thinking and your concentration. And every month you get a bill and you find out that there's a lot of these hearings, these motions, and you did not understand why there was a hearing on a motion to compel discovery against the other side. And you don't understand why they asked for extensions. You don't understand why the judge ruled against you when you do not want to provide documents, for example, financial documents that you feel they're confidential, but the court says, yeah, you got to provide them anyway. So that is that's a challenge for you. So, but it's also psychologically and emotionally draining. You talk about somebody trying to file, basically asking the court, telling the court that you breached a contract, that you committed some type of unlawful act that pursuant to some agreement that you made with the other party. And because of that, that other party is entitled to collect money from the business that you worked, most of your adult life for, and you basically sacrificed a great deal. And so it is very unnerving. It is very stressful. And it's not something that you should handle yourself. Certainly not. But even with hiring an attorney, it'll be stressful because it's also the financial cost involved with it. The litigation is expensive for two reasons. Number one, the attorney's fees are involved on an hourly basis. Litigation attorneys are expensive. We try to triage things, and in my case, based on stages of litigation, and to see if we can get this problem resolved before it escalates. But for the most part, litigation is, you're talking a few $100s per hour for attorneys, and they range in different rates depending on the location. Plus, there's also paralegal time that has to be paid as well. And then you get your bill, you find that there are email communication that took place, there's phone calls that took place, there's an array of activity that took place. And then, after 3 months, you find that the complaint has been amended, and in essence, it's like starting all over again. The analogy that I can give is basically this is like a really bad video game that you have to go back to square one in some cases. But that's the nature of litigation. Fortunately, the court kind of establishes some deadlines through case management, which basically tells the attorneys, this is the way we're going to handle this case. and we're going to get this case resolved in 12 to 18 months, and you will have deadlines that after this particular date, you can no longer amend the pleadings. After this date, discovery will be cut off. After this date, you have to basically give us all your witness list. In essence, the court will establish very, very strict deadlines in order to move the case forward and give you closure. But that's basically mostly procedural matters, which does not resolve the case. So you ask yourself your question, what can I do if I'm involved in a lawsuit to help my attorney advance this case? And that's a very good question. And when you get into a lawsuit, you got to begin with the end in mind. You got to begin, okay, how do I end this? There are two ways you can end this. Number one, settlement, and I'll talk about that in a few minutes. And number two, going to trial. Settlement, obviously, is what it means. It's settling the case for an unspecified amount, a specified amount, before it goes to a trial. A trial, you're allowing, if it's a jury trial, a group of strangers that have nothing to do with the case make a decision for you, or a jury or a judge. So you're basically saying, we cannot solve the problem ourselves. We want you to make a decision for us on how to solve our business problem, because that's what we go to court for, to have somebody else make that decision for us because we cannot solve it ourselves. Let me talk about settlements and mediation first. Talk about mediation. I think it's very important. Mediation, for those, you may have been part of the mediation process or not, but let me just explain briefly what it means. It's basically an informal conference with a third party. It could be an attorney who's a trained mediator, I'm a trained mediator myself, or it could be a retired judge that also practices in mediation. This is an informal party trained in the process of trying to negotiate settlements and between parties. But it's impartial and cannot make a decision on the case. It is a confidential meeting. It could be done via Zoom, via phone, in person. And it's designed to really give the parties an opportunity to try to get the matter resolved right there. The good thing about mediation is that if the matter gets resolved at that time, then there's no, you have closure, and it's confidential, and it is over. When I receive litigation cases, I try to get them resolved as soon as possible, and I encourage mediation early on in the case. Why do I do that? When I encourage mediation, when we have mediation at the beginning of the case, it gives the parties an opportunity, including my clients, to attempt to resolve the matter before additional legal fees are expended. So it's an opportunity. It's what I call an off-ramp. We don't have all the discovery. We don't have all the facts. We're not going to agree to what the party is alleging, and they're not going to agree to what our party is alleging. We're alleging against the other party. But what it will do is basically give you an opportunity to have that face-to-face meeting with the opposing side, or it could be a video meeting with the opposing side, to try to resolve the matter. So what we do in this mediation conference is basically we hire the mediator. If it's a mediation that is not court-ordered, for the most part, they're voluntary. Both sides would agree to hire the mediator, and the attorneys know a number of mediators, and we can exchange names, and we select one. The mediator sends us a contract. We go ahead and sign the contract, and then usually the parties split the fees equally in the mediator. Once you agree to a settlement, then we arrive at what is called a settlement agreement. Settlement agreement includes all the points of the agreement, whether a party will pay to the other party, whether a party decides not to continue the lawsuit. Usually the attorneys draft this agreement and then is approved by all the parties. It is signed. Usually at the mediation conference, can be done electronically. So then once you sign the mediation agreement, the settlement agreement, the lawsuit goes away. Everything goes away. And what it does is basically the only obligations you have henceforward are the obligations in the settlement agreement. So there are some benefits of mediation. I'm a big proponent of that, simply because of it gives you a number of things. And I had a mediation not long ago, and there was it wasn't federal court, a magistrate was the mediator, and he talked about the 8 C's. These are not mine. I forgot the name of the judge. I apologize. But I decided to write them down simply because they were really good tips, and I'd like to share them with you. That if at the end of this podcast, if you face some type of legal issue, I want you to consider mediating the legal dispute at some point. And I remember a judge, the mediator a case, in her opening, telling my client and telling the opposing side, and she was very blunt about it. She said, "You will settle this case." And she said, "You will settle this case either now or you're going to settle it later." She said 98% of cases get settled. The question is whether you're going to settle it now when you haven't spent a lot of money in law and litigation, or you're going to spend it later after you spend maybe $100,000 in litigation. So you will settle this case. This is your opportunity to settle this case today. So what I find out is that when people spend time thinking about solving a problem, even if they don't resolve it at that particular day, it is very likely that the attorneys will continue the conversation. Your path and your mindset has changed from litigating it in court to continuing to try to solve the matter. And 9 out of 10 times in my experience, the attorneys end up continuing the conversation and the matter gets resolved through attorney negotiation. So at the end, it gets resolved by even spending the time in a mediation. Even if it doesn't get settled that day, that is fine. You began to think about resolving the problem. So I'm going to give you these tips about the benefits of mediation. One is client control. In a mediation, you have complete control of the process. You're in control. The attorneys are not in control. We don't control the process of mediation. You control it. We're there to assist. We're there to advise. But you decide whether you want to continue negotiating or you not want to continue negotiating. You decide whether you want to settle or not settle. You're in control. Cost control. Mediation, the parties split the fees equally. Mediators could range between $400, $600 an hour. You split the fees equally. And I will tell you that spending time on spending money in a mediation conference is a lot more productive than spending in a litigation. I'm a big proponent of that. Comfort. Mediation is in a comfortable setting. Sometimes you can do the mediation from your home, from your office. If not, you go to a nice conference room. They give you snacks. Sometimes they give you lunch if it's a long mediation. I haven't had a mediation that lunch is offered yet. Everything that I've done is via Zoom, but maybe soon I'll be doing an in-person mediation with someone and they'll offer me lunch. Usually mediators buy, which is nice. But it's more comfortable. You're not in a defensive position. You can tell the mediator, please leave the room, I can talk to my attorney. It's more comfortable. Commitment. The mediator, you don't have to make a decision. You don't have to agree to settle the case at mediation. But it's good for you to commit to the process of at least engaging in the conversation with the mediator, with your attorney, with the other side, to try to get the matter resolved. Courtesy. Mediation is about courtesy. We will have disagreements. And we have them, obviously, because we're in court. But the courtesy, the objective is to, through respectfully disagree, and to have our differences and have our points of view and educate the other side about why we feel the way we feel, then we might be able to achieve our objectives. And I believe through courtesy, you win a lot of friends. And I remember in law school, I was actually an insurance professor telling us, I will give you one piece of advice. Always be polite. And that's to remember that. And I remember a second piece of advice that I think that's when I went to when I got sworn in as an attorney 18 years ago. One of the judges said, write to an attorney, opposing counsel, the way you would write to a judge. And those are two pieces of advice that I've always stayed top of mind. And there might be occasions that attorneys get heated. Attorneys are human beings, and we really believe in our cases. We believe in our clients, and sometimes it's difficult. But I do remember that advice in terms of writing to opposing counsel, the way we write to a judge. And if you do that, you'll never get in trouble. Creativity. The great thing about business problems is that, if I say anything great about business problems, or is the ability to be creative, is that you have a white canvas, and there's so many different options to try to solve a problem when a business setting that we may not have, or we don't have in the issue of, say, family law or criminal law. I don't practice those, but I'm familiar with family law a little bit just because of other personal experience, which I don't have to go into right now. But you can be very creative with business litigation problems, and that's something that I really enjoy, the creativity. Confidentiality. Whatever happens in mediation stays in mediation. The mediation agreement does not get filed in court, does not get published anywhere. Unless it is breached, then you have to deal with that as well. But for the most part, there's confidentiality with respect to mediation process. And there's also compromise. In mediation, and some mediators have said this, that everybody leaves a little bit unhappy. And that's true. You're not going to get everything you expected to get, and the other side is not going to get what he or she expected as well. But you will compromise, and once you finish that mediation, you have closure, you're going to feel a lot better. So that's my tips for the day is basically talking about client control, cost control, comfort, commitment, courtesy, creativity, confidentiality, compromise. I like to add one more, which is closure. You're not in the business of being involved in a lawsuit. You're not in the business of trying to litigate. And in fact, you want to basically, the money that you earn in your business is for you and your family. And I make the joke that I never met anybody that got up in the morning and said, I have an extra few $1,000s, I need to find a lawyer to give it to. It just does not happen. So, our job is to basically help you get out of this legal, I was going to use mess, but I used it already, legal issue that you have, and get you back to your life, get you back to your business. So this concludes episode number 2 of Business SOS. And how can you reach me? You can reach me via email at richsierra.com. If you'd like to find out more about my services as an attorney, you can check out my website at floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. You can also call us at 866-842-5202. Also remember that Business SOS 8 Common Legal Mistakes Business Owners Make and How to Avoid Them is available on Amazon, Barnes & Noble, and ask for it at your local bookstores. You also can follow us. If you like the podcast, I invite you to follow us in Apple Podcasts, Spotify, or anywhere you can see your shows, get your shows. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.